Well, welcome to our presentation on Chapter 14, the Illinois License Law. As a reminder, on your Illinois State Broker's exam, you're going to have 100 multiple choice uniform questions from general types of questions throughout the textbook. And then you're going to have separately 50 state of Illinois specific questions. Now the Illinois portion of the state exam, these 50 questions, are going to come from the information in your book wherever you see a picture of the United States. As you're going through each chapter, each paragraph, each chapter, occasionally you'll see a picture, an icon of the United States. Now, why they couldn't put a picture of the state of Illinois there, because they're referencing Illinois law, I don't know. But so those 50 state-specific questions will come out of each chapter where you see a picture of the United States. That's actually Illinois law that you have to know. Now, of the 50 questions, besides being found throughout all the different chapters, about 30 are going to come right out of this chapter here, Chapter 14. So everything in the textbook that talks about Illinois law, you have to know for the Illinois portion. And then specifically, you want to know all the information in this chapter, the Chapter 14. So we'll try to cover all the high points of it and the content you have to know, but you can't know this chapter too thoroughly. It's the most heavily tested chapter on the state exam of all your 23 chapters in your textbook. We'll go through the rules and the articles of the Illinois License Act, and we're going to try to really cover a lot of this for you. But remember, there's no substitute for a good, thorough reading of Chapter 14. Now, this can be a tedious and occasionally boring chapter at times, so do take study breaks as you need them. All right, let's get into this. Within the three divisions of the Illinois Department of Financial and Professional Regulation, the IDFPR regulates about 225,000 total licensees from over 70 different kinds of professions and businesses, including architects and acupuncturists, athletic trainers, psychologists, dental professionals, detectives, pharmacists, veterinarians, accountants, beauticians, morticians, doctors, nurses, and just a number of other professions. One of the largest divisions within the three divisions is the real estate division. We account for about 80,000 licensees, and these are found in other of our various real estate specialty licenses as real estate managing brokers and leasing agents and appraisers and home inspectors, school instructors, and so we're a very large division, and we are so large we have our own, not only our own division, but we also have our own real estate coordinator, who is a full-time employee of the department that has their own full-time staff and whose sole job it is to administer the Real Estate License Act 2000. Since 1921, we've had a real estate license law. Its purpose was and is to evaluate, supervise, regulate, and when necessary, discipline the individuals in any of the activities of those engaged in the real estate profession here in Illinois for the protection of the Illinois consumers and the public. This license law was enacted to protect the public. It's been updated, modified, and expanded over the years. Today it's called the Illinois Real Estate License Act 2000, and it is administered by the Illinois Department of Professional Regulation through its real estate division by and through its real estate staff. So we'll refer to the department as we go forward as the IDFPR. You might ask, where does the money come from to fund the real estate division in Illinois and all of its activities and pay for the staff and all the regulatory things that they go through to monitor and administer the Real Estate Act here in Illinois? And the four funds that are primarily used to pay for and to operate the Real Estate Division, are the Real Estate License Administration Fund, the Real Estate Research and Education Fund, the Real Estate Recovery Fund, and the Real Estate Audit Fund. So all of these are important. A couple of these I'll talk to again even in a later chapter more specifically. But basically, the Real Estate License Administration Fund is the one that pays for the day-to-day operation, the day-to-day staff, the day-to-day expenses of running the real estate division here in Illinois. The Real Estate Research and Education Fund is a separate fund. It's held at the University of Illinois. It provides annually money for real estate education scholarships, primarily to minority students. There's another fund called the Real Estate Recovery Fund, which is a fund that the department regulates, and they keep money in case individuals are injured by the unjust acts or illegal acts of one of our licensees. And if that person isn't able to recover money directly from that licensee, they can go to the Real Estate Recovery Fund and satisfy themselves with monies that are held in that fund for the protection of the public, anyone who's been injured by the illegal acts of one of our licensees. We'll talk about that more in a later slide. The Real Estate Audit Fund, there is a special fund that is put together that pays auditors. Auditors are individuals that work for the department, the real estate division, and they go from office to office, occasionally unannounced, and also follow up on maybe complaints that are being made against an office. And they go and they do audits in those offices, if you will, discovery of what's going on in the office, its office operation, and its primary purpose is to see that it isn't the office isn't somehow violating the Illinois License Act that we're going to be talking about here. Secretary of the Illinois Department of Professional Regulation, and as we've mentioned, this is a big job. This is a huge division in our state government in Illinois. The secretary, the head of that, is appointed by the governor. The governor appoints the secretary, and then the secretary actually is allowed to appoint their own heads of their various divisions to assist in managing the unwieldy, this very large licensing regulatory body that we have. The secretary then is the one that's, if you will, hiring these various heads, and in the real estate division they'd be hiring what we call as the real estate coordinator. The real estate coordinator is a full-time state employee whose sole job it is to administer the real estate division of the IDFPR. He or she reports directly to the secretary of the IDFPR. I think the important thing is to note that the real estate coordinator, who is someone, they have to have held a managing broker's license, and with that license they will surrender that to the department during their term as coordinator. And while they're employed by the IDFPR. So they're not actively involved in the real estate business, but when they leave the IDFPR, the IDFPR, their license is reinstated, and then they can continue to work in the real estate business if they want to. They are the ex officio chairman of the Real Estate Administration Disciplinary Board, which is the main body of individuals who advise the coordinator, as they and the coordinator are direct liaisons between the department and the profession. The coordinator also prepares and circulates educational material for all licensees. They may appoint other committees as necessary, and basically with the READ, they and the coordinator and their staffs are charged with supervising all the real estate licensees in the state and, of course, all their real estate activities. The Real Estate Education and Disciplinary Board acts in an advisory capacity to the coordinator regarding professional conduct of our Illinois licensees and our real estate companies, as well as it assists them in conducting hearings in disciplinary cases. There are 15 members of this committee, and they're all voluntary. They're all appointed by the governor. 12 of these, so the 15 members is important. A further breakdown is 12 must have been actively licensed in the real estate business for a minimum of 10 years. 3 of the 15 members of the Real Estate Administration Disciplinary Board, 3 of those members are unlicensed, are just members of the general public that sit on that committee. Who needs to be licensed? Now, be sure you've read all of the activities that would result in needing a real estate license. There's a number of them. I'm just going to summarize a couple of them for you. But do read all that, that's part through on page 254. In summary, any person who's involved in selling, exchanging, negotiating, purchasing, renting, auctioning, leasing real estate for others, which is really the important term there when we say for others, needs to be licensed. Anyone who advertises as they're being engaged in the real estate business, or who assists prospects resulting in the sale, exchange, lease, or rental of real estate needs to be licensed. So the department has recently added wholesaling to the list of activities that one must have a license in to engage. And this is a little technical, but you need to know that wholesaling is a process in the real estate business where one person, let's say a potential buyer, would get a seller under a contract and then actually sell their rights in that contract. It's called assigning their rights in the sales contract to another. You can do one wholesale type of activity and not have to be licensed. But if you do 2 or more wholesale deals in any given year, 12-month period, then you need to have a real estate license. Wholesaling, by the way, is different than flipping. In flipping, someone actually takes title to the property, turns around and resells it. That doesn't necessarily need to be licensed if you're doing flipping. You can do that on your own without being licensed. But wholesaling, if you do 2 or more, quote, wholesale activities where you're basically selling your rights in a sales contract to another party, you'll need to be licensed. And we'll say this a couple of times, for people that should be licensed, that need to be licensed, and they're not licensed, the department can fine you up to $25,000 per each occurrence. Who does not need to be licensed? Anyone who deals with their own property in any real estate matter with their own property, or their regular employees who deal with the owner's property. But once you start dealing with many owners or other owners, then you're in the business and you need to be licensed. Also, these people do not have to be licensed. Attorneys in fact, attorneys at law, receivers, trustees, bankruptcies, administrators, executor guardians, sort of a one-time deal for, as part of a court process, don't need to be licensed. Resident apartment managers. If you live in a residential apartment building and you're managing units for, say, a real estate company who's managing those for an owner, you're excluded from being licensed as long as you remain a resident property manager in those units. If you change your primary residence, you move away from that multi-unit building, then you no longer can be a resident apartment manager, or if you are, then you're going to have to be licensed. So as long as you're living there, you can manage without being licensed. Officer or employee of a federal, state, or governmental agency. MLSs don't have to be licensed. Railroads, other public utilities, and people who work for them don't have to be licensed. So dealing with their own property, individuals don't have to be licensed. And those are the other ones that are kind of important to kind of remember, the ones we're pointing out here. Continuing on who doesn't need to be licensed. a couple of other areas that you might be thinking about and whether or not they fall under the Illinois License Act. Any advertising medium, whether it's internet-based or whether it's print-based, and all they're doing is they're advertising properties for sale, the Zillows of the world, if you will, or the maybe print-based newspapers that used to always have listings in them all the time. They don't have to be licensed. Even though they're marketing real estate, they're not really marketing to bring buyers and sellers together, so they don't have to be licensed. A lessee of a residential dwelling unit refers more than 3 tenants and receives no more than $55,000 for 2 months. What this means is that if I were a licensee and you are a tenant lessee in an apartment building, I could pay you a referral fee if you sent me business, if you sent me tenants. But I'm limited to what I can pay you as an unlicensed regular citizen, if you will, in my apartment building as a tenant. I'm limited to what I can pay you. I'm either limited to pay you a total of $5,000 over a 12-month period, regardless of the number of referrals. 5,000 is the max, or I can pay no more than 3 referrals for whatever they total over a 12-month period. So I'm limited to the amount and the total number of total compensation I can pay somebody who's unlicensed who might send me business. Exchange companies like MLSs, these timeshare exchange companies are exempt from having to be licensed. Obviously, existing timeshare owners, like all owners, are exempt from being licensed. Whether you're a timeshare owner, whether you own your own property and you're selling it by owner, you don't have to be licensed. Any person that has an auction license and is doing the auctioning, is doing the calling, doesn't also have to have a real estate broker's license, as long as that's all they do. If that auction owner should then leave the podium and start working with people that showed up at the auction and negotiating with them and are giving them marketing material and are engaging them in contracts, then they're going to have to be licensed. But as long as the auctioneer only does the calling, not required to be licensed. People that run Airbnbs, and of course their clients, the owners, their clients, don't have to be licensed when individuals are leasing their personal residence through either a hotel or through a Airbnb type of arrangement. There's a civil penalty if you practice real estate, engage in those activities for others, and you are not licensed. The department can fine you $25,000 per occurrence. The requirements to receive a real estate broker's license include being a minimum age of 18 years of age, good moral character, a high school diploma, or a United States equivalent of a U.S. high school diploma. So if you got a diploma that is tantamount or equal to a high school diploma in the United States, but you got it in another country, that will still qualify you. You have to complete 75 hours of approved real estate courses. Eventually, you're going to also need, remember, to take 45 additional post-licensing hours. So really, the total number of hours that you need to take and keep your broker's license is actually 120 hours. So you get 75 hours now when you originally become licensed, and then you'll take your 45 hours of post-licensing at a later time to keep your license. We'll talk about that 45 hours in a little bit. If you don't do your 45 hours of post-licensing within your first renewal period, you lose your license. So essentially, you have to take a total of 75 pre-license and 45 hours of post-licensing education for a total of 120 hours. And of course, you have to pass the written state exam, which is obviously what we're trying to prepare you for as you go through your pre-licensing classes. If you're the applicant for an Illinois broker's license is also currently licensed as an Illinois attorney, he or she is exempt, the attorney is exempt from the education requirements. However, they must still take and pass the Illinois broker's exam or managing broker's exam, whichever exam the attorney wants to take. The big deal with the attorneys is they've exempted themselves from having to take the coursework. Although I will tell you that most attorneys, when they go to sit for the Illinois managing broker or broker's exam, still take some sort of prep course before they sit for the state exam. So they're not completely exonerated from doing some preparation. Now, the managing broker's license requires a minimum of 20 years of age, good moral character, high school diploma or U.S. equivalent. They have to complete 165 hours of total coursework, but don't forget that they took 120 to get their broker's license, so they only need additional 45 hours. And don't forget that there is a work experience with the managing broker. You have to have been a broker for 2 of the last 3 years before you can take your additional 45 hours courses, managing brokers courses, and then sit for the managing broker state exam. And of course, there's another state exam that you have to take a managing broker's exam. But for some of you that are thinking someday you'd like to go out on your own and manage your own office or have your own office, you'll need to become a managing broker at some point in time. But it's going to be a minimum of 2 years before you're going to be able to take your additional courses and sit for the managing broker's license. But if that's something you want to do, that's great. Go get your managing broker's license and manage an office, or manage a branch office for maybe a large company that has a number of offices. You could also manage a branch office for a large real estate company. Now, what about corporations, limited liability companies, and partnerships? They also receive a license, have to apply for a Illinois license. It's called a broker's license. Think of it as a corporate broker's license or an LLC broker's license. The owners of the businesses must also hold managing broker's licenses. So if you're actively engaged in an LLC or a partnership, or if you're active in a corporation, all the general partners and or office managers that are actively involved, active is the critical word here, must have managing broker's license or a broker's license if you're active. Non-residential leasing agents or groups of residential leasing agents may own more than 49% shares of stock. What we're really saying here is if we have licensees that are residential leasing agents, they're not allowed to have a majority share in any real estate LLC or corporation or partnership. No person or partnership or business entity shall be granted a license if any owner, limited partner, director, managing a member has been denied a license within 5 years and being barred by practice by the department. They won't allow that person to become a partner or owner or director in a real estate company. No corporation or partnership itself will be granted a license if one of the non-participating officers is barred from real estate practice by the department. So if anybody in your organization has ever been barred by the department, whether they're active or not, your corporation, your LLC, your partnership will not be granted an Illinois broker's license. So be careful who you bring on as partners and owners and managers, active managers.
And of course, we have the residential leasing agents. These are individuals that engage in residential leasing. It's a limited scope license. They can't do anything other than residential leasing. They can take a 15-hour course and take a residential leasing agent exam. They can actually be less than 21 years of age. They can actually be as young as 18. Take the 15-hour class, take the leasing agent state exam. We do allow leasing agents in Illinois a 120-day grace period before they actually have to go and take their state exam.
After you pass your state exam and affiliate with a sponsoring broker, this is all done online at this point at the IDFPR online services portal. And the department wants you to know that you're going to do all this online. They want to become a paperless organization. So all of this stuff, getting licenses and transferring licenses in Illinois is all done online at their services portal. After you take and pass your exam and you go to the IDFPR website along with your broker, your sponsoring broker, you'll get a link, and after you fill out the paperwork, you'll be able to download your license and your pocket card, which is like a mini license. I'll show you one in a second. So after you pass your state exam, you're going to take all your paperwork, you're going to go to your sponsoring broker and say, you're going to sponsor me, let's go through the online paperwork. And typically they'll walk you through it. You can do it by yourself too, but they'll go online with you and help you fill the material, fill out what you've got to fill out and submit the paperwork that you have to submit if you need their help. And then after the department gets that, they'll look it over, they'll send you a link, and voila, you can go and download your license and your pocket card. Now you're going to keep your pocket card in your purse or wallet. It's kind of like a small mini license. You can even keep it on your phone now in an electric file on your phone if you like, or on your iPad. The idea is that you're supposed to have this pocket card available to anyone who wants to inquire if you in fact are actively licensed. You've got to present that to them and show them that you're actually licensed. Your actual license, your big license, your frameable license must be displayed or available for inspection in your sponsoring broker's place of business. And this is what the license and the pocket card look like. The big license, of course, that's going to be hung up in your sponsoring broker's license, or in office, I should say, or the big license that you see on the left will be put somewhere available for inspection by the department. So as long as it's available to them, that's all they care about. Now, it used to be you had to physically display them. And then on the right side is that pocket card. That's your little mini license that you keep with you either electronically or by paper form, and must be presented if anybody wants to demand and see if you're in fact prove that you're actually licensed. If you're changing real estate firms, leaving one firm and going to another, your managing broker will then go to that portal, and within 24 hours of your leaving them, they'll go to that portal, IDFPR online service portal, and they'll notify the IDFPR that you're no longer being sponsored by them. Your license will become inactive. Now, if you go to a new broker, if you transfer to a new sponsoring broker, they'll do the same thing within 24 hours if you're going to the new firm, and they will tell the IDFPR through the portal that you are now being sponsored by their firm. So everything's done now online through that online portal. Changing your address, very important with the department to know where everybody's at. They don't like people changing addresses, whether their office address or their personal residence, and not letting them know immediately. So if you change your address as an individual licensing or a business, it's the licensee's responsibility, obviously the designated manager of that office, to notify the department of any change of your home or your office address. So that has to be done immediately. Now notice, it is your responsibility to notify them about your change of address. It would be my responsibility as your managing broker, sponsoring broker, to notify them of any change in the address of the office. So you have to assume that liability and notification to the department if you should change your home address. And this must be done immediately, okay? So if you're bringing in new stockholders, or if there's new principals of the office, or new partners, new general partners, new members of the LLC, it requires that the IDFPR be notified immediately. If they're changing the managing broker, or one of your branch managers, or one of the principals, IDFPR must be notified immediately. So there's little wiggle room for changing managing brokers, which says that if you do want to change a managing broker, it's okay, but someone from your office has got to contact the department and ask for a 60-day extension to continue to operate while you replace the managing broker. If you don't do that, the department will just shut your office down after a period of time. So if you either notify them immediately that you do not have a managing broker and you're not going to get another one, which means that you're going to close the office, or if you want to replace the managing broker, then you need to get that 60-day extension. Otherwise, you basically got 15 days to shut the office down and everybody move to some other office. Expiration and renewal of licenses. Inoperative or expired licenses are prohibited, licensees are prohibited from engaging in the real estate business because they are unsponsored. So if you don't have a sponsoring broker, you can't engage in the real estate business. Or if your license expires and you don't renew it, or if it's been revoked or suspended or invalidated, you cannot practice real estate. So you can only operate in the real estate business under an operative license. Newly licensed brokers, you need to be, and this is you will need to complete a 45-hour post-licensing course before your first renewal date. But in reality, you most probably will need to complete this requirement shortly after you are sponsored. I'm going to talk about this in another area here, but this 45-hour post-licensing courses, 3 15-hour courses is what they are. You're probably going to need to take that before you're actually required by law to take that. You're required by law to take your 3 15-hour post-licensing course before your first renewal date. Now, if you look towards the bottom, your first renewal date is going to be April 30th of the next even year. April 30th of the next even year is when your broker's license is going to expire. You need to take your 3 15-hour or 45-hour post-licensing course requirement by that time. But in fact, because of some changes that the department has put on the supervision of newly licensed people, your broker is probably going to require you to take that before you have to, which is that renewal date for your broker's license. Managing brokers renew every 2 odd years by April 30th. So each odd year on April 30th is when managing brokers renew. Each even year by April 30th, that's when Illinois brokers renew. And then leasing agents renew every 2 years on July 30th. Again, they would be on the same years as the brokers.
Non-residents, people that are licensed in other states that have reciprocity agreements with Illinois, if those states have reciprocity, all they have to do to get an Illinois license is to go and pass the state portion of the Illinois exam. Now, mind you, they must keep their residence and their office in that other state. As long as they're in the other state, they can get an Illinois license. So this would basically be for the states around Illinois, even though we have Nebraska and South Dakota, Georgia, and Connecticut, Colorado are involved. Typically, we're talking about the states that are contiguous to Illinois, where we have these reciprocity agreements. I will tell you that Missouri does not have a reciprocity agreement. So if you're in one of those states, you want to stay in that state but practice in Illinois, you can do so, but you have to pass the Illinois portion of the Illinois state exam.
Renewal without paying a fee. Certain licensees may renew their license without paying any licensing renewal fee. Those exempt include those that were on active military duty or engaged in training or education prior to induction in military service, or they were serving as the real estate coordinator with the department, or perhaps they are employed by the department. A license that has lapsed for over 2 years cannot be renewed or reinstated. So after you pass the state exam, you've got 2 years to get your license. If you don't, you're going to have to start all over again. The licensee must repeat the entire educational and state testing requirements. So you've got that 2-year time period to get a sponsoring broker. Don't let that time go by and not do that. And again, that change of address is very important. If you haven't notified the department and for some reason you haven't got your renewal information and therefore you didn't pay your renewal fees and therefore your license expired, the department's not going to have any sympathy with you. It's your obligation that the licensee know your obligation to let the IDFPR know where your residence is. This really isn't important to know for the state exam, but as long as your book talks about initial license fees, when you go to get your broker's license, you're going to send a check for $125. You get your managing broker's license. When you're making your application, that'll be $150. Leasing agent, their initial fee is $75. And then your renewal fees are slightly more. And by the way, these change occasionally. And as I've said, this is not really important state exam stuff, mainly because oftentimes it changes. But I thought I'd put this in here simply because since your book refers to it. We mentioned this before, I'll mention it again. After you get your broker's license, when do you have to renew it? And the answer is April 30th of the next even year. So whenever you get your broker's license, the next even year on April 30th is the deadline to have taken whatever requirements for continuing education that you need to take and submit your application for renewing your broker's license. If you miss that April 30th of the even numbered year date, if you don't renew by that date, your license becomes inoperative and you better not be practicing real estate with it. The department's even got to the point now where they issue demerits, if you will, for people that have missed their deadlines, because tracking that has been such a difficult thing to do. Even though it's important for them to do, it's difficult to track everybody all the time and sometimes take weeks and weeks. And so now they're actually going to be fining people if you don't do your CE in time. So it's one thing that you miss your renewal deadline of April 30th of even years. It's one thing bad that you do that because you're not supposed to be practicing at all. But then if you do want to be practicing real estate after that, they're going to find out that you didn't do what you were supposed to do, taking your continuing education requirements, and they're going to not only make you take them again, but they may even fine you for missing your renewal period. We'll talk more about that later in our sessions. The managing brokers, their renewal date is April 30th of the odd numbered years. Businesses, they renew on October 31st of even numbered of years. And the leasing agents also renew in the even numbered years as of July 30th. So those are the expiration dates of the licenses that if you're not renewed by, you have to sort of quit the business, if you will. And if you do come back into the business, you're going to have to pay back fees. You're going to have to take your courses anyway, and you may be subject to fines for missing those deadlines. Now, speaking of continuing education, as we said, brokers' licenses, managing broker's license, leasing agent's license, they expire in a 2-year framework. The renewal process is going to include that when you're renewing your license, that you pay a license renewal fee and take any mandatory continuing education classes that you have to take. Now, reminding you, as first-time license renewals, as brokers, you're going to need to take not the 12 hours I'm going to be talking about that everybody else in the business is going to be taking, but as new renewal Illinois broker licensees, you need to take that 45 hours of post-licensing classes by that. And as I said before, the reality is you're probably going to have taken it by that time anyway. The the real rule here is that everybody's basically taking, as brokers and managing brokers, 6 hours of CE each year. Since it's a 2-year renewal period, that's where the 12 hours comes from. But the real rule is 6 hours of CE per year. In addition, the managing brokers take another 12 hours of what are called broker management courses. So managing brokers, when they renew, they basically have a 24-hour CE requirement. When you renew after your first renewal period, it'll be 12 hours, like all the other 80,000 licensees in Illinois. Okay, you'll be 12 hours. But your first renewal is going to be that 45-hour requirement. After that, it'll be 12 hours for the 2-year period, or 6 hours per year. And then we've put down there the course content of what's in these CE courses. I don't know that they're particularly important to go through all of the course content so you can see what's involved with it. But I do think it's important to know that when you do your CE courses going forward, there's going to be sexual harassment training that's now a mandatory part of the curriculum. So while the other course content areas for CE courses is important, I think it's also important you know that every 2 years when you meet your CE requirement, there's going to be a sexual harassment component to that. As far as the 45-hour post-licensing course, remember, to renew your broker's license the very first time, you won't take 12 hours of continuing education courses like everybody else. Instead, you have to have your 45 hours of post-licensing education completed. Now, that 45 hours is basically taking 3 15-hour courses. There they are: applied broker principle, risk management discipline, transactional issues. Those 3 15-hour courses you have to have done by your first renewal period. But the reality is you're probably going to have these done prior to the first time you have to renew your broker's license. They'll already be completed. It has to do with the department now has a law that's a regulation that says if I'm your sponsoring broker, you can't really represent me by yourself unless I'm with you in every transaction that you're involved in, whether it's working with sellers, working with buyers. So that really does encumber me to hire you, to have you work for me, if I've got to be with you doing everything all the time. I need you autonomous. So in order to be autonomous, you have to have your 45 hours of post-licensing courses completed. So the reality is that you're probably going to have your 45 hours done before your first time renewal in any event. Exemptions and waivers. The licensees that are exempt from their renewal period, or doing their continuing education, if you will, and having to pay their fees as well, are those that have served in the armed services, full-time employees of the department, those who have served as elected officials, and attorneys. Licensed attorneys don't have to do their CE. If a licensee has earned CE hours in another state, some of that credit may be approved by the department, but you have to submit that each course at a time to the department to see if they'll accept it. Other than that, you're going to end up taking your continuing education here in Illinois with an Illinois continuing education school provider. Lastly, and I'm not sure why anyone would want to do this, but if you're holding a managing broker's license, you can have the department revoke it and replace it with a broker's license. So if for some reason you have a managing broker's license, let's say I'm your sponsoring broker, you're all working for me as licensed brokers, one of you decides to go and get your managing broker's license, which is fine. You can work under me as a managing broker, even though you're not the designated managing broker of the office. That's who I am. You simply have a managing broker's license, and you're acting as a broker with a managing broker's license. You got a little higher rank is all you've got as far as your license. If for some reason you don't want that managing broker's license anymore, you can go back to the department and they would swap you your broker's license. The problem is, if you ever want to be a managing broker, you got to go through that whole process again. So I'm not quite sure why anybody would want to downgrade their managing broker's license to a broker's license, but someone might have a reason to do that. You can, and they'll exchange it for you, except that you've got to then start all over again if you want to become a managing broker at some point in time. Obviously, remember there's a difference between the designated managing broker. That's me. I've got my managing broker's license, and I'm designated to run our office. And you who are working for me with a broker's license or a residential leasing agent license, or maybe you have a managing broker's license. You're just not the managing broker of our office. I am designated managing broker. Now, talking about your business and how, whether it's a car partnership or LLC or S Corp, C Corp, wherever your business might be organized at, there are certain things that all businesses have to adhere to under the License Act. One is a place of business. Every sponsoring brokerage company must maintain a definite office or place of business within the state. And at that office, they must display at the office an identification sign of adequate size and visibility on the outside of the office, and then on the inside they must make available or display the office of the licensees of any of the people that they're sponsoring. This even applies to home offices. So you can have a home office, but you still have to comply with the rules of having a sign outside your home office, as well as having your licenses that are sponsored to you displayed inside that office. The rule on displaying of licenses inside is really you just have to have them available. You don't necessarily have to hang them up on the wall, but they have to be available for the department to come in and see who it is that you're sponsoring in your at your place of business. Brokers' offices or place of businesses can't be located in any retail or financial business establishment unless it's in a separate, distinct area. The idea is, this goes back years ago where you'd go into a Sears office at the local shopping mall and you'd go down the elevator at the shopping center, and as you went down the escalator, as you went down to the bottom of the escalator, there would be an Allstate insurance stand down there, kiosk down there. Now, years ago, real estate regulatory people decided that wouldn't be something they would want to see as far as real estate office doing something like that. So if you want to be in a retail establishment, that's okay. It just needs to be in a separate and distinct area. Likewise, if the office is in a financial business establishment, let's say a bank, it has to be in a separate area within that banking area. Exceptions to the place of business rule deal with non-Illinois brokers who are licensed by Reciprocity. They can meet the rules whenever their states call for as far as the place of business rules. So, they're exempt from our rule, but they have, I'm sure, in their state have some kind of rule on where a place of business is located. So if you're licensed by Reciprocity and you're working in another state, you've got an Illinois license, but you're working in Wisconsin, you have to meet whatever their rules and regulations are as far as a place of business.
Branch offices, only a real estate managing broker can supervise or control a real estate office or a real estate branch office. However, a managing broker can actually manage multiple offices. The old rule was that if you were a managing broker, you could only manage one office at a time. So if a company had a number of branch offices, each branch office had to have its own separate and distinct managing broker. Now you can be a managing broker for a number of branch offices. Exceptions, non-Illinois broker, again, licensed by Reciprocity, may be exempt from this definite place of business requirement. Employment contracts, sponsoring managing brokers must have written agreements with any of their, we'll call them salespeople or brokers they employ, or with any other licensee. That could be a residential leasing agent, for instance, with whom they are associated, identifying the licensee as an employee or an independent contractor. So we have to have written employment contracts with everyone that we sponsor. And with those employment contracts, specifically within those written employment contracts, we will designate with that individual whether that we've hired them as an employee or if their status is that of an independent contractor.
In regards to record keeping, in Illinois, all real estate office transaction records must be kept for a minimum of 5 years. Agency relationships. The law presumes you are the agent with the party with whom you are working unless there is a signed written non-agency document. The presumption of agent does not apply to a consumer attending an open house. So what we're saying here is when you start to work with the seller or buyer, the license law assumes you are representing that seller or buyer, that they're your principal, they're your client, and you are their agent unless in writing you have a document called a non-agency document that says you in fact will not be representing them as their agent, that you'll be working with them as a customer or a consumer, I suppose we could say too, but customer is the better term. So in this case, you'd be working with the prospects as a customer then, not as a client, and then offering them what would be called sort of administrative or informational services is what they would be. So you're going to work with the customer, but not in the same level that you would work with a client, or the same relationship you would have with the client, the same duties you would owe a client. There is an exception if, for instance, you would meet a buyer at an open house that you are hosting. That doesn't mean you become the buyer's agent. Public open houses are an exemption. Now, if after you should meet those potential buyers, say the next day, later at your office, they come over to show, and you're going to come over and discuss with them buying some property, then, or answer questions about the kinds of property they might be interested in, then in fact you would have to be representing them as a client or have a non-agency going forward, that you'd be working with them only as a customer.
As far as your relationship with your client, we're going to talk a little bit about your duties to your client. I know we've talked about many of these before, so this will be kind of a review for you. Your first duty is to perform the term of your agreement. Whatever you were hired to do, whatever your employment contract called for with your client, seller, buyer, landlord, or tenant, that's what you need to do. You've got a contractual relationship, and so therefore you have to perform that which you've agreed to perform. You need to promote the best interests of your client, which basically means you have to disclose any material facts about the property or the transaction itself that would be important for your client to know, seller or buyer. A material fact basically is any fact that once known to your client might affect his ability to make a decision or might affect the decision he or she might make, would be a material fact disclosure. And we must make those to our clients. We need to be obedient and follow lawful instructions of our principals. If our principal asks us to do something illegal or against public policy or violate federal or state or license law, we simply cannot do that. And if the client continues to press us to do so, we should withdraw from the transaction. We need to exercise skill and care in what we do. We have to keep confidential information confidential, and of course comply with the Real Estate License Act. Old car might be a way to remember all of these duties. Old car: obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. As far as our relationship to our customers, if you will, non-agency relationships, we still owe customers that we work with a fair and honest transaction, account for their monies, disclosure of material facts, and we can offer them ministerial acts without our acts rising to the level of client-level relationships. So ministerial acts are those things we can do when we work with customers, and harm might be a way to remember this. So disclosure and ministerial acts are two critical elements of duties that we owe to our customers. Harm: honesty, accounting, reasonable skill, material disclosure, ministerial acts.
As it applies to informed written consent, there are kind of two instances where this becomes problematic. The first is if we're involved or we're going to practice dual agency. Dual agency, of course, is where you're representing both a buyer and a seller in the same transaction. It's legal to do that, to have two clients that you're representing in the same transaction, sellers and buyers, as long as they give you written consent and they have been notified of the possibility of dual agency. What really happens here is in our employment contracts with the seller or buyer brokerage agreements with the buyer, there'd be a clause in there that says, Mr. Seller, Mr. Buyer, there's a chance, albeit maybe a slim one, that I will also be a dual agent in this deal. In that case, I want you to read this clause on dual agency so you'll have some notification of that possibility. And then if in fact you are going to be a dual agent, then on the sales contract there'll be consent that both seller and buyer will give on the sales contract to allow you to be a dual agent. So that's how you give this notification of the possibility of dual agency, and that's how you get written consent from both parties, and then you can proceed to represent both of them. The other time where informed written consent comes in is where we have contemporaneous offers. Here's where you have two buyer clients that want you to negotiate for them on the same property. In that case, they have to fill out the contemporaneous offer form. That's found way back on page 116, and I think we talked about it at that time, but just to refresh your memory, that's where you've got two buyers that would fill this contemporary offer form that allows you to represent both of them in negotiating on the same property. If either of them does not give you written permission to do so, then you can't represent that buyer in that instance on that property while you are also representing your other buyer. So maybe you get somebody else in your office to represent one of your buyers while you if you will, pick the other client of yours, buyer client of yours, and work with them, and they can work with the other buyer. But in any event, both buyer clients have to give you written permission in order for you to represent both of them in the same transaction that you would be negotiating for, the same property. Designated agency, that's what we have in Illinois. We're a designated agency state, which simply allows our sponsoring broker the ability to appoint our agents that work for us to become designated agents of someone that our sponsoring broker has a contract with. So it allows the designated agent in our office then to represent a seller, or a designated agent to represent a buyer. So the sponsoring broker can sort of shed or deflect any agency between individuals that he has a contract with, a leasing contract or a buyer brokerage. He can deflect any agency duties by simply designating somebody else to stand in and fulfill those duties. Also, as a designated agent, our clients can't be held vicariously liable for the acts or omissions of their agents. Obviously, this is without their knowledge or consent. So that's part of our designated agency law when we wrote that law some time ago. And the other thing that we include in our designated agency law is that just because you list your property, Mr. Listing Broker, with an MLS, that doesn't make all the other people in the MLS sub-agents of you. And why? Because you're not an agent to begin with. The designated agent is the one representing the seller or the buyer, not you as an office. Therefore, you're not extending any sub-agency, because technically you can't to other brokers by virtue of placing that listing.
So a licensee must disclose to client material facts concerning the transaction of which the licensee has actual knowledge, unless that information is confidential information. So we're talking about disclosure of material facts here, representing the seller, certainly representing the buyer. We must, as agents, disclose any material fact to the other party, if you will, as soon as it becomes available to us, or of which we have actual knowledge as an agent. Material facts would be any fact that a reasonable seller, or in this case, typically we're talking about a buyer or a tenant, would make a decision on and would affect his decision in purchasing or leasing that property. A reasonable person would then look at that material fact and say, yeah, that is an important enough disclosure that it might in fact affect and determine whether or not a buyer or a tenant would either buy or lease that property. That would be a material disclosure. Another way of looking at material disclosures are these are disclosures whereby there's a defect on the property that might reasonably hamper an individual from enjoying or living on the property. Remember, properties are there for habitability. So any defect that might affect the habitability of the property could also be considered a material disclosure. And so we as licensees must disclose any material facts relating to that property as soon as they become known to us, or up until the point that we have actual information of the defect. This business of confidential information, if you are given confidential information, you need to keep it confidential. However, if it's material fact disclosure, you must tell the sellers that in fact that disclosure must be made. You can't use confidentiality as a way of hiding material fact disclosures. And technically, if the seller would say, no, I want you to keep that material fact disclosure confidential or a secret because you represent me and you have to keep all this stuff confidential, then your only option really would be to terminate the contract and let the seller deal with somebody else. So you can't use confidential information as a way of hiding from potential buyers or from disguising your duty to disclose material information, material facts information.
As a reminder, as we're discussing about material facts disclosure, this is why we have the sellers complete the residential seller disclosure report. Way back on page 41, if you want to go back and take a look at it again. 23 major material facts disclosure that the seller is required to make. And therefore, as their agents, we can rely on these statements and pass them on to potential purchasers of the property if they or their agents have specific questions about the working components of the property and other questions that relate to defects in the potential defects on the property. Most sellers have to complete this. There are some exceptions, for instance, new construction, as well as maybe bank-owned properties where the bank really never takes possession of it. They don't have to complete builders, new construction, and say lenders with their REO property don't have to complete this form. But virtually other single-family residential sellers have to. And remember that buyers must be given a copy of this prior to their making an offer. If they're not given this form prior to their making an offer, and there's a contract that's drawn up, they can actually rescind that contract, cancel it within 3 days of being notified of this form if they were notified after they signed the contract. And again, if during the term of the listing term, if the seller finds additional material defects in the property, he has to go back and make a new updated disclosure report.
So as it relates to material facts, agents must disclose material facts and any latent or hidden defects of property that they're aware of to prospective buyers. So we must disclose any material facts and latent or hidden defects. Now, just on the side, there is a defect called a patent defect, P-A-T-E-N-T. Patent defects are visible defects. Those technically you don't have to disclose because they're easily or readily seen. But latent defects, we're duty bound, if we're aware of them, to disclose. I might point out here, isn't this a good idea to make sure that we have our sellers sign that and fill out that seller disclosure, real property disclosure form that we talked about in one of the earlier chapters. Once the sellers fill that form out, then we can rely that there aren't any other latent defects that we haven't been made aware of, and we can then proceed, and if there's any defects in what they've told us, we can disclose those. If they don't disclose latent or material defects, then really that's going to be their issue and not that of the agent. So the agent wouldn't be guilty of non-disclosure of a material fact. So we need to have those residential seller disclosure form, property disclosure forms prepared by the sellers. Material facts include the structure, who you're representing, any dual agency issues, any environmental issues, if you were the agent previously of this property. Of course, if the real estate agent is a party or has an interest in the deal, we must disclose any interest that we have either as sellers or purchasers of property now that we're licensed. Non-material facts. So we want to make sure we know about those latent or hidden defects. Non-material facts. These are not material facts. These cannot or do not have to be disclosed. The first is whether the occupant of a property had HIV or other serious medical condition. You can't do that. HIV is protected. So if sellers have HIV or AIDS, that is a condition that cannot be disclosed by the agents. These others are non-material facts that if agents want to disclose, they can, but they don't have to, and would be held harmless if they did not disclose these other non-material facts because they don't affect habitability. For instance, stigmatized conditions, which is number 2. Stigmatized conditions would be conditions that might affect they might be related to ghosts or murders or criminal or gang activity or suicides. The types of things that have occurred on the property that don't affect the physical condition of the property. Those you don't have to disclose if in fact you don't want to. 3 issues not found on the subject property. We're only duty bound to disclose those issues that are really found on our property if there are, because we could be made aware of those. If there are extraordinary conditions outside the property, we probably would be held harmless for those. We get environmental issues sometimes that we might have to. So your book might be a little gray area as far as your book is concerned. Physical defects that don't affect value, again, conditions that don't have to be disclosed because they're considered non-material facts. Handling client funds, escrow account regulations, very important. We want to know everything we can about escrow accounting, even though most of those of you that are getting your license or have a license will have broker's licenses. You won't be managing brokers, but you still should have an idea of what happens with earnest money and how earnest money, or escrow funds, I should say, are held. Earnest money, escrow accounts include not only earnest money but also security deposits. So our escrow accounts, where we hold earnest money of buyers or security deposits of tenants, first and foremost must be held in federally insured depositories. The deposits of earnest money must be made within 1 business day of contract formation. So as soon as we have a, quote, contract, that would be both parties have signed the document, within 1 day of that event, we have to deposit earnest monies in these escrow accounts. Escrow accounts should be non-interest bearing unless both clients give us written direction to place them in interest-bearing accounts. So they give us a writing that says they should be in interest-bearing accounts, and that writing should also include who will get the interest from the escrow accounts. Does it go to all the seller, all the buyer? Are they going to split it or whatever? But that must be identified in that writing. Escrow money should not be withdrawn from the account if a dispute arises as to who should receive the monies. What they're saying here is until you're given written instruction by both parties do not remove or withdraw from the account earnest monies and dispose of them. Either give them to the seller or give them to the buyer. You'll only dispose of earnest money, you'll only release earnest money when you have written direction by both parties or their legal representatives. Licensees may respond within 24 hours upon receipt of a request to examine or audit escrow accounts. When you first set up your escrow accounts, one of the things you'll do is notify the department and give them a document that will show them that you in fact are holding earnest monies. It'll also tell them who's responsible for them and also the depository that you're going to be keeping them. That triggers where they can come in your office and say, okay, we know you're a company that has earnest money accounts. Let us see your earnest money record keeping. Each sponsoring broker who accepts earnest money shall maintain in an office or place of business a bookkeeping system consisting of the following: a journal, ledger, monthly reconciliations, and a master escrow account log. So when you keep your escrow accounts, you have a certain format that you must account for your earnest monies. They can be by electronic format. You can do it just by paper format. It doesn't have to be a sophisticated system. But if the department comes in to examine your earnest money escrow account records, they're going to look for a journal. A journal is going to be a list, just like your journal for your checks that you have in your checking account records. It'll be a journal of each day's transaction in date order of what monies went in and what monies went out of your escrow account. Then you'll have ledgers set up. Each ledger is for each account, so we can look at each escrow account and look at each ledger and see what transaction, what's going on with each transaction. When the earnest money was deposited for that particular deal, when the earnest money was released, or what earnest money is still within your account for that particular transaction. Monthly reconciliations within 10 days at the end of each month. You must reconcile all of your accounts so they balance, and you'll actually put that on a master escrow account log that will be one sheet of paper that will show virtually every dollar that has gone in or has gone out of your escrow accounts and what the balances are. So a master escrow account log is one sheet of paper that gives the department one quick look at what the status is of your escrow accounts, what the balances are, what's still outstanding, what deals still have to be done.
Over the past several years, a new phenomenon has taken place in our real estate offices where we have the growth and creation of what are called office teams. Over 25% of our agents in our real estate offices now work with a team or within a team. Now, what has happened is typically we have a very successful real estate broker, does a great job at listing property, becomes a bit overwhelmed with servicing all their sellers and negotiating all of the offers, so the agent begins to organize a team of people to work together as a group. So a real estate team is a group of real estate agents who work together and share or split commissions. Rather than working with one real estate agent, you might be working with a team as a whole. There are no set procedures that all real estate teams must follow, but team members almost invariably pitch in for each other and share the team spirit and share team commissions. A client can contract with any licensed team member for assistance. If one agent isn't available, they can contact someone else. Someone's always there, even if the client has been assigned to the care of a particular agent. Anybody in the team can help them. So there are some benefits to our sellers and our buyers that work with teams. A can contact then any of the licensed team members, but they all work in coordination with one another. Often they even have a sales assistant that works with that team. One agent might be in charge of handling buyer phone calls and duties on listings, while another might be escorting buyers on home showings, tours, or holding open houses. Another member of the team might be drawing up purchase orders, purchase offers, or managing the lending process with the buyer client, or maybe attending home inspections as buyers go through that. So the roles of the team members depend on their experience and their affinities, and sometimes their duties can even overlap. Incidentally, teams can significantly benefit you as a new agent as you learn the ropes, providing a measure of training and mentoring. So for new sales associates, if it's possible to join a good team, that might be a good idea for you. The big concern that the department has is the team in the marketing, promotion, and advertising, and make sure that these are disclosed and that they don't sound like the team is in actual real estate office. So all advertising has to be visible, and the office thereby, so we don't cause the public to think that the team is really the listing brokerage office. So a team, some of the rules here are the 2 or more licensees can make up a team providing brokerage services. And they can, as they advertise, represent themselves to be part of a team or group. They just don't want that team or group name or their advertising to seem to mislead the public into thinking that they're the actual brokerage firm. They're only a team within the brokerage firm. They're still supervised by the same designated managing broker and the same sponsoring broker. So they're all still sponsored by a designated managing broker. The team doesn't mean a separate, organized, incorporated, or legal entity. So teams can't use misleading terms in their team names like company, realty, real estate agency, associates, brokers, properties, or property. So you can't use those terms in team names without maybe running into those being misleading terms where people might think the team is the actual real estate office.
Advertising regulations, as far as real estate brokers, brokerage companies advertising, brokers must include in all ads, and by the way, this applies to electronic media as well as print media, web pages, emails, social media, Facebook, Twitter, any ads that brokers place must include their business name, and if they're part of a franchise or franchise affiliation. If you don't do that, that's considered a blind ad, and that would be not in accordance with the license law, and could you might get a discipline against you if you did that. So our blind ads are prohibited in Illinois. Those would be ads that don't include the name of the business and/or its franchise affiliation. Advertising can't be fraudulent or deceptive or inherently misleading. Advertising must contain all the information necessary to communicate to the public accurate and direct, readable, comprehensible manner, in a readable, comprehensive manner. And while I'm on that, while we're doing this advertising, we also, if it's a listing that we're advertising, let's just talk about that for a second. If we have listings, properties in our ads, in addition to the broker name and or affiliation, we must include the location of the property. Doesn't have to have a street address, but needs to have a town or geographical area. So if our advertising is also including properties, we must also include this geographical area disclosure. Licensees cannot advertise their services to the public through any media without listing the business name of the broker with whom she is affiliated. And if the broker advertises his name, not the business name, but if the managing broker also advertises his name, we must include that he's the managing broker in the ad. So if his personal name is not identified, that's okay, but if we do have his name somewhere in that web page or someplace in that ad, we must have an indication that he, in fact, is the managing broker. Advertising signs. Real estate brokers can't place any ad signs on a property without the written consent of the owner or the owner's agents. Typically, we get this permission to advertise under the listing agreements that we sign with the seller, but in order to do any advertising, including putting it in a multiple listing service, our sellers must give us written permission. As it relates to real estate agents selling their own properties, there are a couple of disclosure requirements here. The first is that in selling your own property, you need to let the public know that they're not dealing with just any ordinary citizen, that they're dealing with an Illinois licensee. So that's what all of these things we're going to be talking about, that's the premise these are all based on. So on your for sale signs, you need to put, when you're selling your own property, broker-owned or agent-owned in ads or in any marketing materials. This also includes any yard signs. Now, you can use your brokerage company's yard sign if they permit it, if they allow it. You can use your brokerage company's sign, and you don't have to put agent-owned or broker-owned on it, because obviously people will know that this has something to do with a real estate office or a real estate licensee. So that sort of gives the public some disclosure that they're not. This isn't a typical for sale by owner. You must disclose your license status on any of the contracts, whether it's a listing contract or whether it's a sales contract or a lease. You would want to put under seller or buyer or landlord or tenant, whichever part of the deal you're in, that you're an Illinois real estate licensee or Illinois licensed real estate broker, something to that effect. As far as phone book listings are concerned, or any online directory where the public has access to it, anytime you place your ad in any of these directories or in phone books, if people are still doing that, then you also have to make sure your sponsoring broker's business name is also included in those ads. Compensation. It's unlawful for any licensed salesperson, if you will, broker salesperson, to accept a commission or other valuable consideration from anyone except the sponsoring broker. So you will only get your monies from your sponsoring broker. No one else can pay you directly. Must go through them. Licensees must disclose any ownership interest above 1% in any third-party provider of services related to the transaction. So if you're dealing with, let's say, a buyer, and you refer the buyer to a mortgage company, and you or your company owns more than 1% interest in that mortgage company, you must disclose that to potential buyer, that you, in fact, that is a controlled business relationship, and that you, in fact, or your company has an ownership interest. A sponsored licensee may create a non-licensed corporation whose sole purpose is to receive compensation from a sponsoring broker. We do allow our sponsored licensees, even though they're sponsored to a sponsoring broker, even though they're not running the company, they can form their own corporation in order to receive compensation from the sponsoring broker. So you can organize yourself as a corporation, Mr. Salesperson, if you will, as a corporation to receive compensation. And by the way, this is really done more for liability aspects rather than IRS tax implications. But it is possible to do that. Bear in mind that if you do set up a corporation in order to receive compensation from your sponsoring broker under a corporate form of ownership, there's only one shareholder, and that needs to be you. A licensed personal assistant must be sponsored by and compensated by the owner broker. We mentioned that earlier, just like any licensee. Personal assistants. Illinois says if we hire personal assistants, they can either be licensed or unlicensed. The big deal is if they're licensed, that's a good deal, because then your licensed personal assistant can do all kinds of things for you, working on your team, if you will. The licensed personal assistant can show property, can hold public open houses, can negotiate contracts, can give your clients any information that you want them to have. But licensed sales assistants, at that point that they're licensed, they're going to be licensed to your sponsoring broker. Even if they work for you, they're licensed to the sponsoring broker, and therefore they have to meet all the same requirements other licensees have to meet. So they have to have an employment contract, have to determine whether they're going to be independent contractors, employees, any monies that they receive as licensed personal assistants. Even though they work for you, monies have to come from the broker to them. Unlicensed sales assistants, well, those rules don't apply, and they can be employees and paid by the the licensed broker that they work for. So they really can be part of your team and you can direct their activities. But if they're unlicensed, they're basically do secretarial and administrative functions for you. Technically, they can't deal directly with sellers and buyers as far as negotiating or any sort of contractual obligations. They're basically administrative in function. As an unlicensed sales assistant, they cannot receive any compensation that has been a part of any commission structure, so not in the form of commissions. So if you are going to hire a licensed or unlicensed sales assistant, you want to make sure you sit down with your broker ahead of time to determine all of these issues, whether they're going to be licensed or unlicensed, how they're going to get paid, who's going to pay them, and whatever obligations the sponsoring broker has got to adhere to in dealing with these licensed or unlicensed personal assistants. If we violate the license law, what can the department do to us? So as you're going through this chapter and you're looking at all the various things that can get you in trouble, ultimately this is what the trouble can be. They can refuse to issue you or renew your license. They can suspend or revoke your license. They can censure or reprimand a license. They can place a licensee on probation. And they can also impose a civil penalty of not more than $25,000 for each occurrence or discipline that they mailed out. Causes for discipline. Pages 274 and 275 have a whole host of things that if you violate can cause one of those disciplines we just talked about. And sometime you need to read all the way through them. I'm not going to go through each and every one of them. I'm going to sort of highlight the high points on page 274 and 275. But do read them through thoroughly at least one time. I think it's a good exercise for you to do. So here's a couple of the high points. We'll start on page 273. Making false or fraudulent representation in attempting to obtain a license or be convicted of a felony. When you go to get your license, you have to make certain disclosures. One is that if you've ever been convicted of a felony. The other is maybe you make a false representation that says that, in fact, you aren't in arrears in your Illinois student loans when, in fact, you are. Attempt to subvert or cheat on the licensing exam. If you use any misleading or untruthful advertising. If you use any trade name or insignia of membership in a real estate organization of which you're not a member. So if you hold out that you're a CRS, a Certified Residential Specialist, this is a very prestigious, I think, designation given by the NAR to people who complete the CRS program, and you hold yourself out to be a CRS and you're not. You could be held to discipline. So be careful if you hold any of these designations and then you don't renew them or you don't continue taking courses to renew your designations, you can have those designations revoked, and there you are continuing to use them illegally. If you act as an undisclosed dual agent, obviously very serious, you can be disciplined. If you fail to account to monies coming into possession of yours that other people are entrusting with you, those would be those escrow account kinds of rules. That's why we have those. If you fail to deposit in your special non-interest-bearing accounts those monies that belong to others. If you fail to make all escrow accounts available to the department within 24 hours. If you fail to furnish copies of documents that of real estate transactions that you've had. You've got to keep documents of your real estate transactions, and you've got to keep records of your earnest money accounts for a minimum of 5 years. If you fail to, by a sponsoring broker, to submit termination documents within a timely manner, you can have your license disciplined. So if someone leaves you, you've got a 2-day period of time to give them their original license so they can go to the new broker. You can't drag your feet and withhold that from them purposely. If you pay a commission or valuable consideration to any person for acts performed in violation of the License Act, so you pay someone a commission and they're supposed to be licensed and they weren't, so that's in violation of the Act, you can be held liable. If you commingle your money with monies of others, if you display a sign on property without the written permission or advertise without owner's permission, if you engage in a violation of the Illinois Human Rights Act, which prohibits unlawful discrimination, you can be disciplined. Where you're a licensed attorney, you can't act as both lawyer and broker in the same transaction. That would be a violation of law. So if you're a lawyer broker in each deal, you have to decide whether you're going to represent the parties as a lawyer or represent the parties as a buyer, but you can't represent both and be paid for both services. If you violate any provision of the Illinois Real Estate Time Share Act, you can be disciplined.
These are a few extra clauses that I put in that could cause discipline. You may or may not find them somewhere in your reading, but the department sort of identified these as either clearing some items up recently or they've added some that weren't in the license law. So I decided to just throw them in here for you. So you may or may not find these in your textbook on Chapter 14. But I think these additional clauses that the department has recently added, I'll go through all of them pretty quickly here. Cheating, they now specifically make cheating on any examination, particularly continuing education exams, an offense that would violate the license law and could have you reprimanded by the IDFPR. So that sort of makes sense. So whether you're taking your state exam or whether you're taking CE exams, no cheating allowed. Compensation, you technically then, and your designated real estate broker technically can't pay unlicensed people who are not a party to a transaction. Now this is a little weird in that you can actually pay for a referral directly back to a seller or directly to a buyer who's doing business with you and did a deal with you. You can actually pay that party to the transaction, if you will, a referral fee. But basically any other unlicensed individual, you can't pay any other fee to or give them any sort of compensation. Credit card payments, you've got to make sure that any credit cards that you're using are valid. They haven't been expired, declined. Not really that important. Criminal convictions, important to note that before you get your license, as you're making an application for your state exam, the department's going to ask you if you were found guilty of any felonies. If the answer is yes, and if that's the truth, if you have been, you want to tell the department the truth. Don't try to hide it from them. Just because you've had a felony doesn't necessarily mean that's going to eliminate you from getting a license, but the department will want to know specifically what that felony was in relationship to, and then they can decide whether or not they will, allow you to sit for and get your license, sit for the exam and get your license. But so when you're making application, make sure that on that question, as far as have you been convicted of felony, if you have, tell the truth. The other thing is, if after you've gotten your license, if you've been convicted of a felony, then you need to, within 30 days of your conviction, notify the department so they can sort of track exactly what that felony is about. As I said, just because you get a felony or had a felony doesn't mean you'll be denied a real estate license. Licensing status, make sure on any form that talks about property data information. If your name appears there, that your licensee status also is indicated there. Good moral character, again, that gets back into making false when you make false statements on your application. Make sure that if you've ever had your license revoked or suspended in another state, or even here in Illinois, maybe it was a beautician's license or something that got revoked, in addition to those felonies that I talked about, that you tell the truth and make sure that you make full disclosure to the department on any information about your background. Guaranteed sales plans, we've talked about that over and over again. Proof of sponsorship, if you are asked for your proof that you in fact are sponsored, you want to, that's why you keep that pocket card that we talked about, either in electronic file, or if you keep a small paper file of it in your wallet or pocket. If one should ask for you to prove that you are a properly sponsored, licensed real estate broker, you'll have that pocket card, which will explain have all the information that will prove that out. Unlicensed practice. Again, if you don't do your CE and you continue to practice real estate on an expired license, you can certainly have yourself reprimanded. So,
other causes for discipline: if you're guilty of discrimination by a federal HUD administrative judge, or by a federal court, or by a state court in violation of the Illinois Human Rights Act, you can have your real estate license disciplined. If you offer a guaranteed sales plan and you don't adhere to the rules for offering guaranteed sales plans, so we might want to read what those guaranteed sales plans requirements are, you can have your license disciplined. Other causes for discipline: if you haven't paid your Illinois income tax, if you haven't paid child support, or if you haven't paid your Illinois guaranteed student loans, you can have your license revoked or refused to be renewed. Brokers will not have their licenses disciplined if there was an unlawful act or violation conducted by someone associated with them that sponsoring broker, managing broker, had no knowledge of. So if one of your salespeople or brokers that are working for you, Mr. Sponsoring Broker, and they did something illegal and you had no knowledge of, or had cause to have knowledge of, then you probably would not be vicariously liable for their actions. Got to be a little careful with that, because the law is pretty strict, saying that you're responsible for all activities. So if you didn't know of them, they were doing something clandestine, something that was very underhanded and kept from you in a willful manner, then maybe you could back out and say you had no knowledge of, and you won't be held responsible along with them. The statute of limitations for disciplines against your license is 5 years within the alleged violation. So if there's a statute of limitations then of 5 years on the department bringing an action against you for violations of the Illinois Real Estate License Act.
One of the additions to the Illinois Real Estate License Act 2000 is this use of continuing education citations by the department to reprimand individuals who have not been doing their continuing education. This has been a problem with the IDFPR since actually they probably developed CE and the requirements for people to take CE courses, where individuals haven't been doing that. And they've been chasing after them. Sometimes they go for a couple of different renewal periods and still don't do their CEs, and the department's got to chase them down. They've got to make them take their courses. They sometimes fine them some additional late fees and other penalties. But it's been a real problem. So what the IDFPR does now is that if somebody doesn't do their continuing education, and they continue to work in the real estate business, they start to give these citations to those individuals. And these citations are kind of like fines, is kind of what they are. And it will help them then monitor and discipline individuals that not only haven't done CE for a particular cycle, but maybe are egregious in doing it over a couple different cycles. You can actually end up losing your license. So with a CE a citation, if you get one of those because you haven't done your CE, and what happens at the end of each of the CE cycles, the department does an audit of everybody's license. So that's how they find out if you've taken your CE. They have all of the real estate schools letting the department know all of the people that have taken their continuing education courses with the approved CE schools. So if your name pops up that knows that you've not gone to any school, they know you haven't done your continuing education. And then you get a letter from them, depending on when that happens. Typically, it's months after. They don't get them right away, but typically months after the CE cycle, you get a letter, and you could get a citation saying that you haven't done your CE. So yeah, the CE will include a fine. It usually doesn't require a public discipline. In other words, you don't really make something on their website that red flags you unless you get 2 or more citations. And you can get them pretty heavy penalties on this, up to $2,000. So, and they can take further disciplinary action as well if there are repeated CE violations. So you want to make sure you do your CE at the time periods that we talked about earlier today, or earlier in our lectures, when we talked about that our renewal periods that come up every 2 years, on the odd years for the managing brokers, and every 2 years for the even years, 2 even years for our real estate brokers. Make sure you do whatever your required CE is within that period of time, and don't be late with it. The real estate recovery fund is one of the things we talked about earlier. When you get your original license, everybody who applies for the original license puts $10 of their application fee goes in the recovery fund. These monies are monies that go into the recovery fund in order to make, the purpose of which is to, if any member of the public that is injured by someone from our profession, and this person is not a licensee, they're a member of the public, they have been injured by the acts of one of our licensees, monetary injury, they can go to the recovery fund and recover monies from that. Now, it's a real strict process, and it's actually more complicated than we make it out to be in our textbook here. But it does provide a bit of a safety net for our our members of public here in Illinois if they've been injured by some egregious act of one of our licensees. For instance, if one of our licensees should embezzle, say, a seller's money or a buyer's money and then absconds with it, or obtains money from them or other valuable goods from them under false pretenses, or by trickery or misrepresentation or deceit or even discrimination, that unlicensed member of the public can go to the recovery fund for compensation. It's important to know that if you, as a licensee, should cause a loss from the recovery fund, your license is automatically terminated, and you can get it back. You have to go through an appeal process, and then you're also going to have to pay back any funds that they paid out, the department paid out of the recovery fund, plus you're going to have to pay any interest that may have accrued on that as well.